Welcome everyone to another exciting Legal Tech Talks session. My name is Frances Anderson, I'm the MD of Net Law Media. Today, I'm actually delighted to introduce a really insightful and thought-provoking interview with two leading industry figureheads on the Legal Services Regulation Report 1 year on. Now, I'm not going to do my standard introduction, which I normally do. I'm going to leave that to the co-host, but I am thrilled to introduce Clive Coleman, who is a British legal commentator and journalist who will be taking that mantle today. Now, before I pass over to him, as I normally do, just to give you a little bit of housekeeping, what I want you to do is, obviously this is going to be looking at the regulation. Do join in, put your thoughts in chat, the Q&A function. If you'd like to actually join in, put up your hand, because it will be great to get you involved. And we'll be monitoring that throughout the session, and it would be great to have your thoughts on what's being discussed. Now, without further ado, and less from me, Clive, I'm going to hand it over to you.
Thank you very much indeed. Well, hello and a very warm welcome to this Net Law Media Tech Talk. As you've just been told, I'm Clive Coleman. I'm a former barrister, recently departed BBC legal correspondent. That was a role that I occupied for 10 years. Now, today's event marks the 1 year anniversary of Professor Stephen Mayson's report, Reforming Legal Services Regulation Beyond the Echo Chambers, dramatically titled. It resulted from a 2-year independent review of legal services in England and Wales, with more than 340 interested parties consulted. Today's a chance to understand this seminal report, to see what's happened in response to it in the course of the last year, and to look at what's coming down the track, down the line in terms of legal services reform. And it's also a chance to face down one of the great challenges of our time and indeed of our profession, and that is to make legal regulation fascinating and even a little bit sexy. And Stephen and I will do our very best to achieve that this afternoon. Now, the report recommends significant changes to the regulation of legal services in England and Wales. Among them, it addresses the widespread public misconception that somehow everyone offering a legal service in England and Wales is already regulated. The report recommends a single sector-wide regulator for all legal providers, and that includes the currently unregulated sector and providers of technology-based legal services, or Law-Tech. And alongside that, it recommends a single point of entry for a complaints and redress system for consumers and for small businesses. Now, these changes and the other changes that the report recommends may be on their way sooner or later. You may welcome them, you may fear them, but by far the best way to understand them and to prepare for them is to hear from the horse's mouth. I hope he'll forgive me for referring to him in that way. I mean, of course, the report's eminent author, and he is, as I've said, Professor Stephen Mayson. He doesn't need much introduction, but let me give him a very brief one. Stephen was called to the bar in 1977 by Lincoln's Inn, where he's now a bencher. He's also the chairman of its regulatory panel. And after a period as a tax lawyer with one of the Magic Circle law firms, Stephen developed an international reputation as a strategic advisor in the legal sector, working on a range of strategic, financial ownership and governance issues. More recently, he's held a number of non-executive directorships and retained strategic advisory relationships with law firms and law-related businesses. Since 1992, Stephen's also held professorships in the UK and abroad, and he's presently honorary professor of law at University College London. He has, of course, a particular interest in the regulation of legal services, as his authorship of this report demonstrates. He was, after this report, I should mention that he was appointed by the Lord Chancellor to the expert panel supporting Sir Christopher Bellamy's review of criminal legal aid. So how are we going to do this? How are we going to cut and slice this today? We're going to do it as follows. Firstly, we're going to begin by asking Stephen to give us a helpful recap of the main limbs, the main issues raised by his report and the main recommendations. I'm then going to give Stephen a thorough grilling in the form of a brutal cross-examination on the key questions and issues that emerge from the report. I'm joking, of course. It will be a polite, frank and open exchange. And then I hope that we will have some time to take your questions. So please I'm speaking to Stephen, and as I'm putting questions to him, things will be occurring to you. Please put those into the Q&A or the chat and we can pick them up. So Stephen, can we perhaps begin, please, with a brief summary from you of the main elements and the main recommendations of the report?
Thank you, Clive, and thank you to NetLaw Media for hosting today's event, and indeed a welcome from me to everyone who's on the call. Yes, summarising the review, bearing in mind that it was a 2-year project resulting in a 300-page report and 50 recommendations, let me try and distill it as briefly as I can. To me, the big issues were several. First is the inflexibility in the 2007 Legal Services Act. It's a large piece of legislation, it's very prescriptive in places, and it's very cumbersome to change. And in a fast-moving market and a sector like law is today, that's a real limitation in terms of regulating those who do or want to participate in it. Secondly, there were difficulties with conflicting and I thought in some cases inappropriate regulatory objectives, where public interest and client interest and professional interest don't sit happily. And is it really the job of regulation to promote public legal education at the profession's expense? Isn't that more of a marketing issue, you might say? Third, the structure at the moment is not risk-based. It's framed around the 6 reserved legal activities and professional title. Again, in terms of moving with the times, that imposes some pretty significant constraints on where we go and how we go. There are continuing issues with multiple frontline regulators, and despite the tensions being reduced in recent years, there are still issues of a conflict or at least a tension between the regulatory and representative functions of the professional bodies. Real concern is what's become known as the regulatory gap, that is, legal services that aren't reserved to lawyers being provided by those who aren't lawyers. That gap has been widening. It applies to both those who are currently unregulated and to law tech. And I'll come back to this, but I think in the last year or so, given everything that's been happening, that gap has been widening, and it does result in inadequate protection for consumers of services that are not currently regulated. Even within the regulated sector, I have to say there was some unfortunate evidence of continuing incompetence or poor competence amongst even regulated providers, and continuing evidence of poor service by those providers. So it's not as though regulation solves all the problems, but equally the regulated can't use regulation as an excuse against further competition. And then finally, I think as a result of all of that, my big concern was that the current structure results clearly in confusion for consumers about who is regulated, by whom, for what, and ultimately that does raise a big question of public confidence in the whole regulatory framework and in the profession and ultimately in the rule of law. And that, I think, is something that we can't just ignore. So the report made some long-term recommendations and short-term recommendations. The long-term ones, some of which you've already referred to, Clive, were, for my money, a stronger shift to regulating in the public interest and to regulating all providers of legal services. I'm not saying I'm not in favour of consumer interest or professional interest, but I do think in these matters, what happens in the public interest ought to be the overriding concern. It ought to be the overriding driver of regulation. You've already mentioned the idea of a single sector-wide regulator for legal services that applies to all providers, combined with a public register of all of those providers. And I think that would lead to a basis for common standards, for common disclosure to consumers, for systematic investigation of complaints and universal redress for those who are in some way harmed or underserved by regulated providers. And then finally, to replace the current 6 reserved legal activities with a risk-based approach to regulation, and so apply regulatory requirements or interventions on a before, during, or after the event basis that is proportionate to risk. And that's not just to achieve risk-based regulation, but also, I would hope and urge, to achieve a better cost benefit for providers and consumers in where regulation falls and who pays for it. Those were the long-term recommendations, and I did accept and still accept that long-term probably does mean long-term, and we can come back to that later. But I also made some short-term recommendations, and I have to say these were mainly driven by the early experience of COVID-19 and the response to the pandemic, what seemed to be an increasing, even greater unmet need for legal services amongst consumers, and particularly the vulnerable, and possibly increasing risks arising from the ways in which consumers and law firms responded to the pandemic. So consumers were more inclined, I think, to go online and possibly to end up with unregulated providers. Law firms, as we know, and for very understandable reasons, closed their doors, furloughed their staff, and reduced the available provision of qualified and regulated lawyers and others to the consumer sector. So there were clearly some quite significant shifts in the way in which the market was looking as we edged into the pandemic up to June last year when the report was published. So the short-term recommendation, in essence, was for a parallel regulatory structure that would only apply to the currently unregulated providers. In other words, let's leave what we've got untouched. Let's leave the regulated to be regulated, as we know they are at the moment. But let's at least address the problem, the challenge of those who are currently unregulated, but providing quite legitimately non-reserved services. And the two principal limbs of that recommendation, that parallel structure, would be a public register of those unregulated providers, and through that, and because of that, access to a complaints investigation and redress process that either was the current legal ombudsman or something perhaps very similar to it.
Okay, so Stephen, what you set out sounds eminently reasonable. We have everyone registered, so and regulated, so we don't have what some might regard as a kind of wild west of unregulated legal service providers. The sort of historical accident that has led to us having 10 different regulators. That all of this is harmonized, it's simplified, and it's in the public interest because people currently unregulated will become regulated. That all sounds fantastically sensible. Tell me what's happened. It's a year since the report landed presumably on the Justice Secretary's desk. Has it been picked up by the MOJ? Are they working furiously to rewrite the landscape of regulation of legal services? What's happened?
I probably wouldn't use the word furiously in that context, but I mean, as you might expect, there was a flurry of initial interest and comments around the time of publication. Most of it, thankfully, appeared positive, although there was perhaps some predictably anti sentiment expressed, and it was a mix of public and private follow-up. So obviously, I can only talk about the public follow-up to the extent that that is known. As far as the ministry is concerned, I think what we have is statements by officials made publicly last September that seem to accept the issues and the problems of what I described a couple of minutes ago as the regulatory gap. That they accepted that it doesn't seem to make sense at any fundamental level to have a situation where the same service can be provided to consumers. In one instance, it's protected because it's done by a lawyer, and not in the other, where it is legitimately provided by, let's say, an unregulated will writer. So the illogicality of it does seem to have been accepted. They also said at that time that they were willing to explore the proposals in the report for unregulated providers. They described them as really interesting, but obviously that is subject to weighing up the risks and costs of whatever might follow as a result of the report and other initiatives that I'll come on to. So I think I heard that as an acceptance of the need to expand redress. I think the question is how best to do that, and it's not. I accept that's not easy, and it's probably not a quick fix. So at that point, I think it's an acceptance, but now let's wait and see what emerges.
I want to ask you whether there's likely to be more or less regulation, but just before we get to that, is it, as a gnarled observer of government responses to eminent and laudable reports, is there a sense that there isn't a lot in terms of votes in redrawing the landscape of regulation for legal services, but where there is something in terms of vote winning, if you like, and the public interest combined, it's in protecting consumers from unregulated providers of services? Are we in that sort of area?
I think we are. I mean, it would be very ambitious of me to claim that there are votes in regulating legal services and reforming them. But I think if you look at what the Competition and Markets Authority said first in 2016 and again at the end of last year in their follow-up to the 2016 market study, they have a very clear emphasis on this potential for harm or detriment to consumers. As I say, I think has increased as a result of the pandemic, but even outside that. And there's no doubt that the CMA is trying to get government and regulators to focus on transparency, on things like comparison websites, looking at how you make more information about price and quality credibly available. I mean, at one level, it's quite easy to make some of that stuff available to consumers. The question is it available in the right form, in the right way? And as I say, is it credible?
Okay.
The issue of more structural reform, I think, is potentially a more problematic one for all of us. But certainly, the CMA were supportive of the short-term and long-term recommendations I made, and they did urge the Legal Services Board to review the reserved legal activities. So I think you could say there's a sort of momentum building that whether there are votes in it or not, there are risks to consumers that it might not be wise for government to ignore, because if something does go wrong, there have been enough voices saying, we think this is a problem, we think there are issues here. And so the government is aware of them.
Okay. Tell me, give me your view on this. Is there likely to be more or less regulation? And let's think of the two sectors perhaps separately. Let's look at the currently regulated sector, many of whom would regard themselves as being highly regulated, or indeed over-regulated. Are they going to get more? And what about the unregulated sector?
Well, I think, as I said, in the short term, my goal was to leave the currently regulated more or less alone. And so in that sense, there shouldn't be more or less. There's still a question about whether it's appropriate, but I think that's an issue within the current framework. In the longer term, I would hope there would be less burden and less cost to regulation for those who are currently regulated. And I think there is a danger of over-regulation under the Legal Services Act. As I said, it is very prescriptive. There's over-regulation in principle. So for instance, once you're regulated under the Act, even your non-reserved legal activities become subject to the oversight of a regulator, whereas if you were in the unregulated sector, they wouldn't be. So there's a sort of principled over-engineering of regulation in that sense. But also in terms of detail as well, if you look at the way in which ABSs, for instance, were introduced, maybe it's not so bad now, but certainly in the early days, the process for application and approval was tortuous and took a long time. And again, I'm not sure that is a necessary consequence of shifting the focus of regulation. As far as the currently unregulated are concerned, clearly there would be more formal regulation for both the short term and the long term. My solution in a sense is the same. It's registration, it's a complaints process, it's redress. It might well also lead to a code of conduct and the need for professional indemnity insurance.
And how do you
dissociate? Sorry, yeah.
No, I was just going to say, how do you see the redress system running? There is obviously an existing legal ombudsman. Is it something that we'll see an expansion, do you imagine, of the legal ombudsman's service, and they will deal with the unregulated sector, which becomes regulated?
I think that is one of the interesting policy questions as we move forward. I mean, it strikes me that, at least in principle, in the legal ombudsman's service and the idea and the ideals of that service, we do have the makings of something that should almost quite easily be applicable to the currently unregulated sector. The difficulty, and I think where the policy question arises, is that we know that the legal ombudsman has been having difficulties of its own in recent years. I think that's improving, but it might make it difficult or challenging to think in terms of using that platform as a short-term extension into the currently unregulated sector. So I think that's a wait and see. Again, I think in terms of simplicity and transparency for consumers, having the same access to the same complaints and redress mechanism would make most sense. But whether it's robust enough and cost effective enough for that purpose, I think is a matter for policy debate as I hope, move forward.
So you're talking about a system of complaint and financial redress, in essence.
In essence, yes. But I think what goes with that is a sort of shaping of the sector, and particularly the newly regulated, currently unregulated sector, in terms of managing their expectations and clients' expectations of what's required. And that is where things like codes of conduct or guidance from regulators can be particularly effective.
And just to talk about LegalTech, I mean, how do you bring LegalTech into this? I mean, who's registered? Is it the company? Is it the lawyers or non? Well, anyone can be a lawyer, can't they? But those qualified as solicitors, barristers who are working for those organisations, or those who are unqualified, are they registered as individuals, or is it the company that's registered?
Well, of course, if they're already regulated as a title holder, like a solicitor or barrister, then in a way there isn't an issue to be addressed. They're already regulated, and they would have to assume personal or entity responsibility for their use and provision of services through tech. The question in relation to the currently unregulated tech providers is an interesting one, and the view I came to in the report is that as long as there is someone who is responsible to the regulator for compliance and the effective delivery of legal services, I don't think I'm too exercised about whether that's an individual or the entity. It might become a business decision. Again, it is one of those policy questions that would need to be addressed. But for me, I'm not sure I was overly exercised about where that particular responsibility should fall, as long as it fell on someone. Okay. And indeed someone within the jurisdiction and someone who is registered, so that there's public transparency for consumers.
Sure. Now, our attendees will be interested, obviously, not only in the question whether there's going to be more or less regulation, but I think they want to know, what will the cost implications be to providers of legal services under this new regime of regulation as and when it comes in?
I'm going to preface my remarks by saying I didn't have the resource in conducting the review to do a sort of cost-benefit analysis that would have drilled down to the level of detail that I think we would need were we to move forward. But my intention, certainly for the currently regulated, was that the cost of regulation ought to be less in the longer term. If we can achieve scale economies of regulation by having a single regulator and more streamlining of regulatory processes, if we can have targeted and proportionate regulation to the risk, then I think we don't end up with the over-elaborate, over-constructed system we have at the moment, and therefore the cost should fall proportionately. In relation to those who aren't regulated, and again, there's a short-term and a long-term effect, but again, hopefully I would think they're broadly the same. Yes, of course, there would have to be some cost to regulation. But in the conversations I had with those who are currently unregulated formally, many of them choose to be voluntarily regulated. And there are organisations which oversee the activities, say, of will writers, of mediators, of paralegals, and they have registration processes, they have complaints systems, they offer redress, and they often require professional indemnity insurance from their membership. So in some ways, those who embrace regulation are already bearing a cost which I wouldn't expect to be significantly higher in a new structure. And in fact, I think there are models out there of how cost-effective regulation can be achieved, but that is certainly cheaper than that applied to the currently regulated persons under the Legal Services Act. So I think lower for those who are currently regulated, and some cost for those who currently aren't, but probably not much, if any, greater than they currently choose to spend. The issue, of course, it would be for those who currently choose not to be regulated in any way. And my view there is that if they're not prepared to bear a modest cost for regulation, or seek to avoid the cost of regulation, they probably ought not to be in the market in any event.
And what is a modest cost? Is it £2,000 a year? Is it £200 a year? Is it? Do you have any sense of where the cost burden would fall within that scale?
The one I referred to in the report was the professional paralegal register, where I understand the cost is somewhere in the order of £300 a year, which includes contribution to a compensation fund, and of course there's professional indemnity insurance costs on that, but I don't think £300 is unreasonable for being regulated and providing comfort and transparency to consumers. It ought not to be beyond the bounds of most effective and sustainable businesses to afford that. And again, I would expect any decent business to be taking out professional indemnity insurance anyway.
Would there be any additional factors that would have a bearing on cost? I'm thinking about things like the size of a business's turnover, perhaps the volume of complaints that it's generated. Would you be able to keep things at a low cost if you're running a very big business, or you're generating a huge number of complaints?
Well, I think that's an interesting question, even in relation to the current approach to complaint handling and redress. I have a lot of sympathy with the idea of polluters paying for the damage they cause and bearing the cost, a proportionate cost of the burden that they then put onto other people. So I think that's a bigger question, not really about how much an alternative system would cost, but how you distributed that cost amongst providers, and particularly those who were creating most problems. From my point of view, again, I'd have no difficulty in having more of that cost borne by the polluters, those who cause most harm, if that can be achieved in a robust way. I certainly don't see why the majority of providers who are not causing problems should be paying anything more than a contribution to the establishment costs of an effective regulation and complaints and redress system.
Now, I know that you've been in discussion with various stakeholders and decision makers. When do you think changes might begin, and what kind of timeline do you anticipate for change?
Well, obviously, Clive, you probably won't be surprised to hear me say that the timeline is never short enough for me, because I think we need to be doing things now. But accepting the reality of where we are and the issues that need to be sorted out, I think the long-term reform that both I and the Competition and Markets Authority have pressed for is probably at least 5 years away. Although I would note that it's already 5 years this year since the Competition and Markets Authority said in their market study that it needed doing. So we could be looking at a lapsed time of 10 years from their work, and an awful lot will have changed in that time, given that an awful lot had already changed since the Legal Services Act was implemented in 2010. On the short-term stuff, I'm optimistic, and I might be misguided, I guess, but I'm optimistic that something might be possible within 2 years. I think there are ways in which we can address the challenges to consumers, particularly in terms of complaint and redress that ought not to take much longer than that.
It's interesting, isn't it? Because I think in some of the research that you carried out, a huge number of people who had a legal problem within the last few years had gone to an unregulated provider of legal services to get assistance, advice, and even representation to help them through that problem. Now, is it the Wild West out there? Do we have an unregulated sector that is luxuriating in the fact, excuse me, that it is unregulated and that consumers are suffering dire results as a consequence of that? Or is your urge to bring them within regulation to have the whole thing clearly defined for the public?
Well, clearly my drive is to have it defined and to make sure that the public are protected, whatever choice they choose to make. And although many would argue that the current regulatory framework is robust and it does provide protection if consumers use regulated lawyers, if you look at the proportion of legal services that are in fact provided by regulated lawyers, it is a minority of every legal need that's out there. So I think we're in a difficult position. In a way, we do have a good system of regulation, but it just doesn't go far enough. So I do want to see it extended, and I want to see it extended as quickly as possible. What heartened me during the process of conducting the review was the number of currently unregulated providers who want to be regulated. And I know often that's dismissed by those who are already regulated as saying, well, they want the status that goes with being regulated. I don't think that's the driver at all. I think they want the confidence to be able to say to their consumers, you have protection. And I think that's a legitimate commercial aim for the currently unregulated to have. So I don't think it's a Wild West. I think there are a lot of unregulated providers out there, as we know. In fact, as it turns out, we don't really know exactly how many there are, but there are a lot out there, and many of them are ethical and they do want to do the right thing and would like the regulatory framework to help them do the right thing. At the moment, we can't help them, and indeed, there's nothing that the current regulatory framework can do to tackle those who choose to do bad things if they are not regulated already.
It's interesting. The reason I raise it is that I did a piece for the Today programme on Mackenzie friends. And for people who are in any way unclear about what a Mackenzie friend is, a Mackenzie friend is someone who you can take to court if you're a litigant, who can advise you, help you with you prepare your case, your papers. They're not supposed to have rights of audience, but in the light of the legal aid cuts that came in 2013, increasingly they've been de facto getting rights of audience, and they're unregulated. They don't have to be insured. They have no code of conduct. And it was interesting. I was expecting a raft of kind of horror stories, and there may be some horror stories, but actually the people who I spoke to, and this is obviously a small anecdotal sample, but the people who I spoke to felt that they'd received enormous benefit in many cases from Mackenzie friends. And actually judges also were of the view that, you know, in a case where you may have two litigants in person, some help is better than no help. So I suppose I was expecting to see a bit of a Wild West, and it didn't seem to be there.
No, and I think in a way you've hit on what ought to be the acid test there. The question isn't, do we provide excellent regulation and excellent legal services for everybody, when the alternative for many people is no help at all. And that gap between no help and no regulation and excellent help and excellent regulation is just too big for the vast majority of society these days. So we've got to do something in that middle ground. And again, like will rates, Mackenzie friends are often raised as part of that unregulated territory that some people hate, because in effect they're driving a coach and horses through the reserve legal activities and exercising rights in court that aren't available to other people who aren't regulated. And so I think we've got to shift the dial, if you like, on making it acceptable, but making sure that the consumers who use them are still protected. And
Sure.
it just emphasizes the nature of the gap that we're not dealing with at the moment.
Stephen, let me just read you a couple of comments that we've had from Rita Leet. She says, this has just come into the Q&A. She says, the professional paralegal register is optimistic that it can offer the short-term change suggested. We're working hard to bring the will writing sector under our umbrella. And then another comment, she says, we wholeheartedly agree with the proposals and do offer the only independent regulation for the unregulated sector. So moves are already afoot, if you see what I mean.
Yeah, absolutely. And Rita knows that I referred to the to her register in the report itself as an example of what can be achieved at a relatively cost-effective price.
Sure. Let me also just say to people on the call, please do send in your comments and questions to our Q&A, and that gives me the opportunity to then put them to Stephen. But Stephen, there are changes afoot, not just in this country. Let's look overseas and at the US. The US bar associations have historically been strongly against any regulatory reform that would dilute the legal profession's monopoly on legal services. But very recently, we've seen initiatives to open up the market, most notably in Utah and in Arizona, as well as Ontario in Canada. To what extent are these taking on board the lessons from our reforms under the 2007 Legal Services Act?
Yeah, that's a good question. And I think it's very interesting that a jurisdiction or a set of jurisdictions in the case of the US that has historically been against reform now appears in different ways to be almost agitating for it. And I think what they've learned from us is that the sky hasn't fallen in when you allow those who aren't lawyers to do things within the sector and within regulation. We haven't been overrun with crooks and sharks and charlatans. And I think the most interesting thing for me in relation to the US states that have moved, and particularly Utah and Arizona, is that those initiatives have been driven and supervised by the Supreme Courts. And you wouldn't normally associate the judiciary with this sort of ambitious wall-breaking support for reform. But what's driving it for them is because judges every day are seeing the consequences of unrepresented or self-represented litigants. And they can see that there is a much bigger gap emerging at their level, let alone all of those legal issues that never get anywhere near a courtroom. And so their enthusiasm, their commitment to doing something about it, I think is laudable, and it's encouraging.
It's interesting because it's similar to, I've spoken to a lot of judges post the 2013 cuts to legal aid. And, when you took, vast areas of civil law out of legal aid, so, debt, family, property, etc., then a space opened up where people, couldn't perhaps afford a lawyer, but they still had to deal with their legal problem. They either went along and did it as litigants in person, and judges found that incredibly challenging, because if you've got two people coming along to a county court, with the documents in a carrier bag, and maybe one or perhaps both of them maybe not having English as a first language, a 2-day case can become a 2-week case, and it can be incredibly draining on the system. So it's interesting that some of this is coming from the judges. Some of this embracing, if you like, of the unregulated sector is coming from our judges. Yeah,
and I think the other thing they've woken up to is that it's never too early to make the moves in reform. And I guess they're in effect saying we can't afford to wait for the local bars in each state to wake up to this need and agree a set of changes. It needs to happen more quickly than that. So let's get on with it, and we, the judges, can push that forward. Well, of course, they can in the US, because typically it is the Supreme Court in each state that is the ultimate regulator of lawyers. But it's interesting that they are becoming more active in that role, having in reality been quite passive for years.
Couple of questions coming in now. One from Sarah Chambers. She says, the costs of PII have risen a lot during COVID and are still rising. Your proposals might extend the market for PII, but will this reduce the average cost? If not, regulated legal services will become even more unaffordable for vulnerable and even normal people. What could be done about this?
That's perfectly valid observation by Sarah. Of course, it's an issue for the operation of the insurance market rather than regulation as such. I think the question for regulators is whether, in their quest to make professional indemnity insurance mandatory, they impose higher limits than are really necessary for the risks involved, or impose conditions effectively on insurers, like runoff cover, for instance, or continuing to cover those who don't pay their premiums. There are regulator-imposed burdens on insurers that make this market expensive, as well as the actions of the insured. So it's a complex problem. It is connected to regulation, but I don't think it's one that regulation can solve. It needs a much broader and more nuanced conversation. And actually, I'd also say in my experience and in the profession's defense, the insurers don't always understand the nature of the practice that they're insuring. They'll make some pretty generic assumptions, for instance, about a conveyancing practice or a will writing practice. And because that box has been ticked, certain issues and insurance costs will flow, which aren't necessarily proportionate to the actual risk of that insured. So I think there are a number of really complex and interrelated issues here, but I do share Sarah's ultimate concern that if PII is too expensive, then it will drive providers out of the market, or it will drive costs up to consumers, and they will still continue to be underserved or not served at all by a regulated market.
Do you think it threatens the existing professions in the sense that, if you can be registered and regulated without having to go through your professional qualifications, and some Mackenzie friends are making £150,000 a year, I was told. I can't absolutely stand that up, but that was what I was told when I did that piece. Do you think that if you've got a much smaller or lower regulatory burden in relation to a wide number of activities, perhaps low risk activities, we may see a kind of reshaping of the market of provision of legal services and the professions themselves?
Well, we might do, and I might even say that that's in essence what the market needs. I mean, if a lot of legal services are really low risk to the consumer and to society, then it can't be right that a regulatory framework overburdens those providers with regulatory requirements and costs that are disproportionate to those risks. Now, if some of that comes as a cost of being professionally qualified, I'm not saying that I don't want high quality professional people providing legal services in England and Wales, but if that's to be sustainable and valuable to society and to consumers, the cost of doing it has got to be proportionate to the issues that consumers face. And that means we are going to have to reconfigure the market. As I said in the report, I have no problem at all with someone having a professional qualification. I have no problem at all with that professional qualification leading to certain rights as a regulated practitioner. What I have a problem with is no one else being able to acquire those rights as a regulated practitioner if they don't have that title. And I don't want to push the boundaries so far as to saying a professional title is really a brand or a quality mark, but we're not far off it. And so if that quality mark, if that brand is valuable in the market, consumers will pay for it. If it's not valuable in the market, why should consumers pay for it if a regulated alternative was available? That's how markets work. And it's part of the picture of the reconfiguration, as I see it, of being able to meet the needs of the vast majority of the population rather than a small majority of the population who have legal needs and can afford legal services as they're provided at the moment.
interesting observation in passing, which is that, of course, the SRA are bringing in the new SQE qualification for solicitors, which is designed to be, cheaper to promote social mobility, but perhaps in some way nods also to the kind of changes that you're highlighting. I want to get through some of the other points that we've had sent in. This is from an anonymous attendee who says, a key barrier to transforming the regulatory framework within England and Wales seems to be political disinterest and resistance within certain parts of the sector on whether there is a problem and how to solve it. How hopeful are you that things will actually change given the political apathy and culture resistance among many legal professionals?
I mean, it's a very good observation, and it is, of course, part of the nub of the problem here about how far forward we can move and how quickly we might move. I think what I do is, at least in part, hark back to the US experience. The professions there, in effect, are starting to lose the traction they had over the boundaries and the scope of regulation, because a third party, in their case the Supreme Courts, are saying what you have is not tenable, it's not sustainable, society can't afford it, and we need to do something different. I have detected in the last 12 months particularly, I think, a shift in the narrative here, not universal, but an encouraging shift, which has shifted the question from why should we do this to when will this happen? And that's a very different conversation. And I accept in some political quarters, the when question won't be asked, and in some professional quarters, the when question won't be asked. But I'm not sure that certainly the profession remains the main arbiter of what happens next.
Stephen, we've got a question from Aisling O'Connell, who says, what lessons can the legal services sector learn from, it's just jumped up the screen. What lessons can the legal services sector learn from other sectors in terms of regulatory reform? Who's shaken up the system successfully?
Again, good question, but I would expect that from Aisling. The two main other sectors that I think we will typically look at are medicine and financial services. Financial services has had its own issues over the last 10 years or so, and I'm not sure that I would hold that up as necessarily as an exemplar of how to regulate. Not to say we can't learn anything from them, but I'm not sure I'd take that model necessarily and apply it. Medicine's more interesting because, in a way, although it looks like title-based regulation, most of the titles attach to very specific medical activities, whether that's surgery or osteopathy or whatever. And so, in a sense, they have something that's much closer to activity-based regulation than we do, even though at the moment it still looks more like title regulation, if that's how you want to see it. But I think what's interesting about the medical profession is that you don't have to be a fully qualified doctor in order to be a regulated provider of some health services. And if it's okay for health, then what's wrong with having a more graduated, nuanced, risk-based approach in law? And so I think there is something to be learned from that. And they have looked at this idea of registration, separate registration. And I think made something of it. So I think there are lessons to be learned there.
Interesting. Another question from Sarah Chambers. She says, in the last year, the inequalities in access to legal provision between different parts of the country, e.g. housing advice deserts, and between different ethnic communities have increased, with significant divergence in levels of trust among ethnic minorities. There could be some political interest in trying to deal with these issues, so perhaps we could focus more on the relevance of your proposals to them. So in other words, see it as more of an instrument of social justice and social change.
Yeah, and I think that's a very good suggestion from Sarah, as ever, and I think it could provide a very useful hook for a discussion about reform. My concern would be that we shouldn't then look at reform for those vulnerable groups or different groups to the exclusion of others, because I think we've now gone well beyond the point where those who are excluded from the current framework of legal services provision as consumers are the poor and the vulnerable. I think there's a lot of evidence that even the relatively well-off now find that they can't access regulated legal services on a cost-effective or value-for-money basis. So I think this is a much bigger issue than those that affect those groups. But if what Sarah's suggesting is a hook, is an entry point into a debate about the need to do this, then yes, I'm absolutely behind it.
Yeah. Well, your point about, I mean, harping back to the legal aid cuts of 2013, but, it really became, just going to the county court became prohibitively expensive for people, even for middle-class people, really, many middle-class people, because, the civil justice system is self-funding, so the costs of issuing and so forth went up. And, and again, it was into that space that a lot of unregulated providers came, because if they, moderated their costs, then they were simply going to pick up work that litigants who wanted some representation, some advice, were prepared to pay for, or could afford to pay for, where they couldn't pay or meet the price of solicitors and barristers.
I came across a very, I'm not sure whether this counts as humor or excitement or not, but I came across a very interesting quote from someone in the US yesterday, who said that Americans spend more on Halloween costumes for their pets than they do on legal services for the poor. Barbed, but interesting.
It is interesting. There must be some pretty spectacular Halloween costumes on dogs and cats and hamsters around the United States, I'd imagine, based on that. Stephen, let me get one, possibly our last question in. This is from Rita Leet. And she says, risk-based regulation, not title-based regulation, is vital to ensure equality and diversity in the sector. And this goes to the heart of your recommendations, that you regulate on the basis of risk.
Yeah, I mean, for me, it's a combination of activity and risk. So what is the risk connected to a particular activity, irrespective of who provides it? I think Rita's statement would require quite a bit of unpicking, because I'm not immediately convinced that simply shifting from title-based regulation to activity and risk would solve all of the equality and diversity issues that we face. But it may well be, as is the intention for the SQE, for instance, that making those sorts of changes will be part of a package that increases equality and diversity with it amongst the providers of legal services. So I think I agree, but I'm not sure it's quite a cause and effect.
Rita's just sent another short comment in. She said, agreed. So we have agreement there, which is great. Stephen, what would you like? Let's throw forward, let's say 7 years. What would you like the landscape to look like, and what are the most important parts, do you think, of your report that could shape and improve the current landscape of regulation?
Well, I mean, I have to say, in my ideal world, 7 years out, 7 to 10 years out, I'd like to see the world that I described in the long-term recommendations in the report, because I still believe that the essence of those recommendations will provide an approach to regulation that opens up provision to a broader range of people who want to provide legal services, and possibly make it more, and hopefully more, cost effective for those who need legal services to access them. I think the critical question in moving forward from here is how do we characterize the harm to consumers at the moment against which they need protection? And that's not a simple issue, and it's not a straightforward issue, and it probably would provide the key to unlocking whatever might happen next. So I think long-term goal remains the same. The short-term goal, I think, is to drill right to the heart of what will it take to allow us to make that next step forward.
Sure. I just want to apologise to Rita because she had a raised hand, and had I seen it earlier, I could have brought her in to ask the question directly. So apologies, Rita, mea culpa on that one. All right, well, Stephen, thank you very much indeed. Thanks, obviously, to Professor Stephen Mayson for his report and for answering all of our questions today. Also to all of our attendees for their questions, and to NetLaw Media for putting on a fantastic cutting-edge event. Can I wish everyone well in the brave new world of legal services regulation, whatever its precise shape, whenever it comes in, and in the hope that it will improve and won't overburden all of those, and they are the vast majority, who are doing their best to provide high quality legal services. Thank you very much, everybody, and let's hope that we can revisit this, Stephen, on the 2nd or 3rd anniversary of the report, and talk about how some of these changes are working out in practice.
Thanks a lot, Clive.
Thank you.